Welcome to Inside the Deal. I'm Suzanne Stevens. Joining me today is Jeff Whittle. Jeff leads the intellectual property practice for Bracewell and Giuliani. Jeff, we know that there are a lot of corporations out there that are trying to monetize their intellectual property, maybe even more so in the current economic environment. Right. But because of kind of the cumulative effect of some recent cases, it's a little more challenging maybe than it has been. How so?
Well, in many ways, in monetizing intellectual property, companies are looking to either license the intellectual property out, they're looking to sell assets they're particularly not using at the time, or they may be looking to enforce patents, for example, through litigation against third parties. So in monetizing IP, what they'll do is assess what they have in their portfolio and try to go and enforce it or take those type of actions. Well, over the past several years, and particularly even coming into this year, the U.S. Supreme Court and some of the lower courts have kind of curtailed the rights of the patent holder, the person holding the patents or patentee, in terms of making it easier to invalidate a patent and make it more difficult for the patent to enforce.
Well, one case that is pending that we could see some activity on later this year is the Bilski case. And that's been going on for a long time. And it's interesting. It has to do with the ability to patent a business method versus a business process. Explain the difference there.
That's correct, Suzanne. In terms of business methods, what Bilski is particularly trying to claim is a business method of hedging against risk, and particularly related to weather. And it's a hedging technique from a financial perspective. So it's a financial-related business method patent that they're trying to enforce against third parties if it ever issued from the patent office. In Bilski, they can't get it out of the patent office. And so it's been appealed at different levels, and recently it's been appealed to the U.S. Supreme Court, and the U.S. Supreme Court will hear that case this fall, likely.
What are the widespread implications if the Supreme Court upholds that patent and suddenly you can patent a business method?
Well, I think what the courts are really struggling with, if you can patent a business method, it's what they'll be looking to do and the implications, how do you indicate whether someone's infringing that patent? For in a business method, if it's not tied to a machine or there's not something that's transformed by a state or a thing, then what happens is to go enforce it, then what are you looking to see? Are you looking for something that's happening in their mind? Are you looking for something on paper? How do you enforce it? And that's really some of the struggles that the courts are struggling with in that area.
Will the Supreme Court take that into consideration? Is that part of their decision making, how difficult enforcement would be?
Absolutely. I believe it really is. And I think even the lower court made some comment in their case about it, in the lower court case about it, is when you look at the third parties for infringement, how can you tell? What is going to be the difference? What companies are waiting on the sidelines to tell is, what is the scope of this thing? Where is it going? What's the parameters of it? What is patent eligible subject matter? What can I patent and what can I not patent from a business method point of view? The case will likely be decided in the winter of 2010. But what's happening out there is that companies are waiting to see. It's like a standstill. It has like a chilling effect on people filing on business method patents and pursuing because they think, well, the court's going to say that they're not valid. The lower court said that, and it's likely that the Supreme Court is going to say that as their position. Other companies, on the other hand, think that because of the intellectual power in our country in terms of nationally and internationally, that, hey, our whole service industry is involved in this. And because we're gravitating more towards a service industry, we should protect these methods that we're developing from a business perspective. So the court's going to weigh those things and try to come down one way or another on that decision.
Well, it's going to be interesting to see how it comes out.
Oh, yes. I think it's going to be very interesting. It's going to have really a blockbuster effect for quite some time, I think.
Jeff Whittle with Bracewell and Giuliani. Thanks for coming in.
Sure. Thank you.
I'm Suzanne Stevens. Thanks for watching Inside the Deal.